Good afternoon, everyone. Welcome to today's meeting of the Assembly Committee on Growth and Infrastructure. Would the committee secretary please call the roll?
Assembly members Backus.
Present.
Assembly members Brown May. Carter.
Present.
Dickman.
Here.
Gallant.
Here.
Gurr.
Happy to be here.
Karas.
Here.
Moore.
Here.
Wynn.
Here.
Urick. Chair Watts.
And I am here. We have all members present. We have a quorum. We want to welcome everyone joining us today, both here in Carson City, as well as anyone who ends up showing up in Las Vegas and anyone who is joining us remotely. A few quick housekeeping items. Please be sure to silence your electronic devices. If you wish to testify, please sign in at the table in the back and provide a business card to our committee staff if you have one. When testifying, please be sure to turn on the microphone before you speak. Please clearly state and spell your name for the record, and then turn the microphone off after you have finished speaking. And always, please introduce yourself again for the record each time that you speak. We will be limiting public comment today to 2 minutes. We do expect a courteous and respectful environment today, but we will try and have a little bit of fun as well. And lastly, members will be using their laptops to look at handouts and other documents. Please do not take that as a sign of disrespect. So we have 2 bills on our agenda to be heard today. We are going to take them out of order. So we'll be hearing Assembly Bill 117, followed by Assembly Bill 46. And with that, I will open the hearing on Assembly Bill 117, which revises provisions relating to special license plates. Welcome back to the Committee on Growth and Infrastructure. Chairman Moreno.
Thank you so much, Chair.
Whenever you're ready, please begin.
Thank you, Chair, committee members. For the record, my name is Tracy Brown May, and I am the Assembly member that is proud to represent Assembly District 42. My distinguished colleague, Assembly member Danielle Monroe Moreno, and I are happy to be here to co-present this measure. We'd like to officially thank you for taking the time to hear this measure today. We're honored to have with us, although they're not going to take the microphone and testify, it's important that we call out the owner of the Las Vegas Aces and the Las Vegas Raiders. Mr. Mark Davis is with us in the house. Mr. Larry Dowson, the Las Vegas Aces CEO. Ms. Jennifer Azzi, former WNBA player and Olympic gold medalist, now working on business development with the Las Vegas Aces. Ms. Janae Murphy, who is the Aces Foundation Executive Director. And of course, our team mascot, Buckets. As you can see, we have assembled an all-star team to come and present this wonderful bill.
Thank you, Chair. It is so nice to be back in Growth and Infrastructure, the committee that I once chaired. And I said that I would do no more license plate bills, so I'm going to tell you all, never say never in this building because you never know what's going to happen, right? So before we summarize the bill, I'd like to provide you just a little brief background about the Aces. The Aces played their first season in Las Vegas back in 2018. They have made it to the playoffs for the past 6 seasons and won the WNBA championship back-to-back. I'm going to say that again, back-to-back in 2022 and 2023. They also brought a Commissioner's Cup trophy to Las Vegas in 2022, and the championship win included a charitable donation from the league to the ACLU of Nevada. The Las Vegas Aces are deeply committed to making a positive impact in their community through various charitable events and donations. Their initiatives focus on education, health, and wellness, and youth participation in sports. The Aces have organized numerous events, such as the Slam Dunk Health Challenge, which encourages kids to engage in physical activities and healthy eating. They also participate in toy drives, where they donate basketballs, bicycles, and other toys to local charities. Additionally, the Aces have been involved in relief efforts such as collecting and delivering donations for fire relief in Southern California. Through programs like the Lace Up Mentorship Program, They provide mentorship to local youth and workshops covering topics such as recruiting, financial literacy, professional growth, and college preparation. The ACES brought in almost $18 million in revenue in 2023 and led the WNBA evaluation in 2024 at $140 million. During the 2023 season, the Aces led the league in attendance per game at an average of over 9,500 fans per game. And if you haven't been to a game, you gotta go. You gotta go. In 2024, the Las Vegas Aces made history by becoming the first WNBA team to sell out their season ticket packages for the entire season. And like I said, I once chaired this committee, and I had the pleasure of one of the duties of chairing this committee was also chair the interim committee on special license plate. And hopefully Mr. Davis won't remember that when the Raiders came for their plate, I kind of gave him a hard time about the Raiders plate. But he has proven me wrong. He has been an amazing partner in our community in Las Vegas and for the state. And so, in doing that, he has put together an amazing team of leaders, Nevada leaders, a lot of them women and women of color from Nevada. So I would be remiss if I didn't also say thank you to two ladies who aren't here tonight who talked me into making sure we had a plate for the Aces, and they started this conversation a few years ago. And that would be the Raiders president, Ms. Sandra Douglas Morgan, and the Senior Vice President of Government and Community Relations, and you all know her, Ms. Piper Overstreet White. It's because of them getting the conversation started that this team behind us was able to bring this to fruition. So, Mr. Davis, thank you for making me wrong, and thank you for your commitment to our state. And with that, we will walk you through the bill.
Thank you. Tracy Brown May for the record. So as you can see, supporting the ACES Foundation and helping fans to show off their team support is just one way that we can support the team. We do have mock-ups that we're happy to share with you that the team has been working on. We did not distribute them because they are in draft form. But to give you an idea, we're wearing our team colors today. The license plate is projected to be in the team colors, although we'll work through the double letter stack when we get there. The bill provisions are found in your bill. Subsection 1, Section 1, Subsection 1 requires the DMV to work in cooperation with the Las Vegas Aces to design and issue the special license plate supporting the Las Vegas Aces. Subsections 2 through 5 discuss the fees associated with the plates, including a $35 fee for initial issuance and $10 fee for renewal, which is typically found at the DMV. All applicable registration and license fees and taxes, so it's a standard plate that you would get issued. Then there's an additional $25 fee for initial issuance and $20 for renewal, which goes to the Las Vegas Aces Foundation for programs and activities supporting health and fitness, disadvantaged children and families, education, and women's sports. So the mission of the Aces Foundation. That is very standard for all of our special issue license plates. The extra fee is voluntary when you decide to purchase that plate, and every time you renew, it goes to support the foundation. Subsection 6 exempts the Las Vegas Aces license plate from statutes requiring a minimum number of plates before they go into production. And then that's what allows the DMV to create the special license plate. Subsection 8 of Section 1 allows the DMV to accept gifts, grants, donations, or other funding for the plate's production and issuance, so you can offset that if there's a gift or a grant. Section 6 through 8 exempt the Las Vegas Aces special license plates from provision that require the plates to limit the number of separate designs, right? We have that in statute currently. Only a certain number of designs is allowed. And then receives a certain number of applications before the DMV creates them. So we'll be able to put them into production right away. Section 2, 4, 5, and 10 make conforming changes for the provisions in this bill to align the Las Vegas Aces special plate with certain existing requirements and definitions. Section 3 eliminates the prohibition against a new vehicle dealer accepting an application for a motor vehicle registration if the applicant wishes to obtain a special license plate. In so doing, this new vehicle dealer may accept an application for registration from applicants, making it easier for buyers for a new vehicle to obtain a plate. Now, that does not exist currently. In reading the language for this provision, for this bill, and the special license plate, which we have done on several occasions. This is not our first special license plate. The entire bill is very standard except for this provision. So in reading this section yet again this session, we identified that there is a barrier for new dealers who may work with the DMV at some point to issue license plates. And so rather than wait for the need to arise, we figured that it would be good to eliminate the barrier to that currently. So as the DMV continues to pilot new programs with dealers to issue plates or registrations, this would just then allow them the opportunity to issue a special license plate if they chose to do it. It just eliminates the barrier in the future. I'd like to thank you for the opportunity to present this bill today. We are happy to answer questions.
Thank you very much for the presentation. It was great to hear from you two back to back. Members, any questions for our presenters? Assemblymember Nguyen.
Thank you, Chair, and thank you for the presentation. I really appreciate what our Assembly Member Monroe Moreno said about our amazing leaders in the community, like our Sandra Douglas Morgan, and of course her counterpart Piper Overstreet, who are amazing community connector and do so much. So I'm so glad that they are a part of this legacy, and this is great. So bringing to this particular legislation, I think one of those, I guess, newbie questions, since I'm new in this committee and wanting to kind of figure out how did we arrive at $35? Do we think that's a good number? Should we go higher?
Yeah, Tracy Brown May for the record. Thank you for the question. The $35 is already existing in statute, so we tried to not reinvent the wheel. We wanted to stay very standardized and not do anything out of the ordinary, so that's already existing. It's what the DMV currently requires.
Assemblymember Monroe Moreno, but you know, the money does go to the foundation, so you're always welcome to make contributions to the foundation.
Oh, thank you. I just learned something new. I didn't know I can do that. So thank you. Thank you very much. Thank you, Chair.
Thank you. Yes, next season, get in on that raffle. Vice Chair Carter.
Thank you. Yeah, my question has to do, you said you weren't reinventing the wheel, but we just heard a whole lot of exemptions from existing statute. That seems like we're recreating the wheel.
Thank you, Assemblywoman Tracy Brown May for the record. I appreciate that comment. There are a number of specialty plates that have already been issued here in Nevada. There are two pathways to creating a specialty license plate. One gives the DMV the authority to do it and to be able to just go through a process. That was what Chair Monroe Moreno previously turned it back over to the DMV to have the authority to do that. There are also a number of specialty license plates, and I could just talk to you about the Opportunity Village license plate, which was the last plate that I had the pleasure of presenting to this Committee on Growth and Infrastructure before becoming a member of this body. It's standardized language, and it has been done on numerous occasions. The way the DMV does it, you have to go through the process and get pre-approval, and then wait until you have 2,000 applications before you can issue a plate. It limits the number of plates that the state allows through that process. By creating a bill, we were actually recommended to do that by the DMV so that we could get this bill up and running because it is believed to bring a great deal of support into the foundation. At every plate issuance, $25 goes to the foundation. And so if you have only 2,000 plates on the road, right, or say 2,500 plates on the road, that's $50,000 a year in support of the ACES Foundation. The fans would then have the opportunity to do that. So there are two pathways. One is this pathway, which requires those exemptions so that we can get the plate into production right away. The other is through the DMV's process.
Thank you.
Thank you. Members, any additional questions? Okay, seeing none. Thank you very much for the presentation. We will now move to testimony in support of Assembly Bill 117. If anyone would like to provide testimony in support, either here in Carson City or in Las Vegas, please come forward. Welcome. Please go ahead.
Thank you, and good afternoon, Chair and members of the committee. For the record, my name is Trevor Parrish, Manager of Government Affairs for the Vegas Chamber. The Chamber is in support of Assembly Bill 117, which creates the Las Vegas Aces license plate. As Las Vegas continues to grow as the entertainment capital of the world, so too are we quickly becoming the sports capital of the world. With this new license plate design, fans of our back-to-back champions will be able to help contribute to the ACES Foundation, which works to support health and fitness for disadvantaged children and families, as well as supporting education in women's sports. The Chamber thanks the bill sponsors for bringing this forward, and we thank you for your time and consideration of this measure. Thank you.
Thank you very much. Seeing nobody else coming forward in Carson City and no one in Las Vegas, we will move to the phones. A couple of quick things. If you are calling in by phone, please be sure to state and spell your name for the record before making your comments. So with that, AVH, is there anyone wishing to provide testimony in support of AB 117 by phone?
Chair, the public lines are open and working, but there are no callers to testify in support at this time.
All right, thank you. With that, we'll move to testimony in opposition of Assembly Bill 117. Seeing nobody coming forward in Carson City or Las Vegas, AVH, has anyone joined us on the phone?
Chair, there are no callers to provide testimony in opposition at this time.
Thank you. And finally, we'll go to testimony in neutral on AB 117. Welcome, Mr. Sever. Please go ahead whenever you're ready.
Thank you, Chair and committee members. Sean Sever from Nevada DMV. We are neutral on AB 117. We do appreciate the sponsors reaching out to us, or you could say huddling up with us before the game today. We marked this down again, Chair. We do have a zero impact fiscal note on this bill. And we are happy to work with the ACES on this license plate if this bill passes. Thanks.
Thank you. And as far as the fiscal notes go, let's just keep it up. All right, seeing nobody else coming forward in neutral, either here in Carson City or down in Las Vegas, AVH, has anyone joined us by phone?
Chair, there are no callers on the line to testify in neutral at this time.
All right. Would our presenters like to make any closing comments?
Thank you, Chair and Committee, Assemblymember Monroe Moreno. We just want to say thank you so much for giving us the opportunity to present this bill. If you have not been to an ACES game, I encourage you to grab your family, grab your friends, go to a game. The atmosphere is just infectious, and you will be hooked for life. And as the Chair of Ways and Means, I must say, I love the fact that DMV had a zero fiscal note. So thank you, and we hope to earn your support for this bill.
All right, thank you very much. With that, we will close the hearing on Assembly Bill 117, and we will open the hearing on Assembly Bill 46, which revises provisions relating to privileges applicable to information obtained from records and other property of public utilities and certain other entities.
Thank you.
Thank you. Welcome, Mr. Weir. Whenever you're ready, please state and spell your name for the record, and you can begin.
Thank you. For the record, Garrett Weir. That's Garrettweir. I am General Counsel for the Public Utilities Commission. And Chair and members of the committee, I appreciate the opportunity to present Assembly Bill 46. So this is a bill that is essentially designed to preserve the privileged status of any privileged information that is shared with the commission or its regulatory operations staff within the context of a utility regulatory process. Our regulatory operations staff in particular, which intervenes in contested cases and has broad investigatory powers in regulating utilities, has encountered some concern on the part of utilities when it comes to sharing information that is privileged, whether it's a trade secret, other types of privileged status as outlined in law. And so to facilitate the sharing of that information and to alleviate that concern, we're recommending, or we're proposing to very explicitly provide that status is preserved when shared in this particular way. And so it's important to I guess, explain that when information is shared pursuant to the regulatory process for the commission, this occurs confidentially. So when the information is provided, it's not being publicly disclosed where the public can access it. It's being shared generally pursuant to protective agreements if it's other parties to the case. But also when it's shared with the commission itself, there are statutory and regulatory duties that require that confidential treatment, and it's taken seriously. So that's just, I think, an important distinction to make here. Even when the information is shared, it's not made publicly available. It still remains confidential. So another point to make about what's being proposed in this bill is that there is no intent here to expand or restrict any existing authority that the commission and its staff has to access privileged, confidential information, records of utilities. So that is not what this bill is doing. It is simply addressing the status of that information once shared to preserve its privileged nature. So rather than going through the bill as initially drafted, which again, I've explained what the intent is there, we've been working closely with Southwest Gas and NV Energy in particular. They've been working on a conceptual amendment, which you'll hear about shortly. The commission is comfortable that, and our regulatory operations staff is comfortable that we have a meeting of the minds on what we're trying to achieve here. There may be some further edits necessary to the amendment language before you, but ultimately, we are confident that we'll reach a place where there's consensus, at least with the commission and those utilities. So I guess with that, I'm happy to answer any questions about the bill, or I can remain up here maybe when the conceptual amendment is presented and also be available to answer questions at that point.
Thank you, Mr. Weir. I think we'll have those bringing forward the amendment, discuss it, and we'll take some questions at that time. But I do believe we have a question from Assemblymember Backus.
Thank you so much, Chair, and thank you for laying out your intent. And I appreciate that you guys also do work under protective orders, because when I look at the subparagraph 6, it seems kind of clear to me, but I just want to make sure, and I think you made it clear for the record, is obviously everyone's entitled to a privilege under Chapter 49, whether it's attorney-client. We have other statutes that govern maybe trademark protections. In such situation, and if a body wanted to release that information to you, especially with attorney-client privileged communications, I take it that this provision right here that provides that there would be no waiver of that privilege is that what I'm understanding your intent behind this bill is?
For the record, Garrett Weir, yes, the intent here is to not affect for it to not be a waiver of the privilege or for that to be otherwise affected. Now, with regard to sort of the right to assert a privilege, there's, I think that's an area of dispute, which, frankly is the reason that some of these discussions have occurred with this bill. The existing law contemplates the commission and its regulatory operations staff having access to all books and records of a utility with particular exceptions identified. There's a subsection that references like personal or personnel records, those sorts of things. And there are certainly constitutional protections, I think, in the context of litigation, where you wouldn't want a party's attorney-client communications related to strategy, that sort of thing, shouldn't be able to be revealed to other participants in that process. That seems reasonable. But there is, the way that the language exists now, there is broad authority, in my opinion, enabling the commission and its regulatory operations staff to have access to things that are privileged, and for the utilities to have an obligation to provide information in certain circumstances, as regulated entities.
Okay, so I may have really misunderstood that when I was reading this, because when I think about, so there's two things. There's work product, that would be a litigation subject to and usually I think that's under the Nevada rules of civil procedure for work product aspects. But when I think about absolute privileges, I think of Chapter 49, where you have patient, doctor, you have attorney-client, and those are communications. So if, and I know there becomes challenges when you have in-house counsel. I'm not talking about that. Let's just keep it as simple as one of our utilities. This is applicable to, I think, it had in here like the two different types, new electricity, it seemed like, in the gas services. If a company was communicating with outside counsel, to me that seems like Chapter 49 would provide an absolute privilege, that communication. And when I was looking at these provisions, I was taking it like, oh, but maybe there was like a communication where a lawyer wrote back to its client providing detailed advice regarding maybe some provision under Chapter 703, and they wanted to share that information with you, but they didn't necessarily want to share their entire file leading up to that ultimate communication. And so therefore maybe that would come over to PUCN with like, subject to this provision, it would be protected so that they wouldn't have to open up that attorney-client privilege. And so it sounds like that's not what this does.
For the record, Garrett Weir, it does that in certain instances. For example, a utility seeking cost recovery, let's say, of legal fees, right? This would, if they wanted to maintain the privileged status of attorney-client communications related to the scope of the work performed, the billing, that sort of thing, that the commission and parties to the commission's proceedings would probably want to be able to scrutinize to determine whether those costs should be recovered through rates charged to customers. That's the sort of thing where if they wanted to provide that information, they would be able to support their recovery of those costs without that privilege being lost. There is, again, the implications, I think, of the language that I was talking about more broadly, the powers of the commission to review even privileged materials, is essentially, there are going to be times, and in practice, this is how it has been playing out, is when there's a dispute among parties to a contested proceeding about, in discovery in these cases. Ultimately, the commission or the presiding officer, usually commissioner, will resolve those disputes by actually gaining access to the privileged, the material that's for which a privileged claim is made, to determine whether it is in fact privileged or should be protected from disclosure to other parties, even pursuant to a protective agreement.
Can I ask just one more follow-up question? Go ahead. Thank you so much. So I look at exceptions under NRS 49.115 that provides when there's no privilege under the attorney-client privilege. And so I'm just not obviously familiar with your guys' subsection or like the chapters that govern the PUCN. So is there another provision that basically provides that that the PUCN's entitled to attorney-client communications, and that this provision, or maybe Chapter 49 doesn't apply? I'm a little confused by that, and I'm just not familiar, and I would love some more information on that.
For the record, Garrett Weir, and yes, it would be helpful if the bill actually contained, that provision, but we're not seeking to change that. But it's the section that appears immediately before where this bill begins, and it would be NRS 703.195. And it provides, I can read that section, except as otherwise provided in subsection 2. So except as provided in subsection 2, any commissioner, any officer or employee of the commission who is designated by the commission, or any other officer or employee of an affected governmental entity who is designated by the affected governmental entity, may examine, so this is where the, operative language is, may examine during regular business hours the books, accounts, records, minutes, papers, and property of any public utility, alternative seller, provider of discretionary natural gas service, or provider of new electric resources who does business in the state with respect to such business, regardless of whether the book, account, record, minutes, paper, or property is located within the state. So essentially, there's this description of the authority to inspect those materials, and then the exception when, specifically limiting that authority. The only exception that is identified in statute in this specific section is subsection 2 that reads, no personnel records of an employee may be examined pursuant to subsection 1 unless the records contain information relating to a matter of public safety or the commission determines that the examination is required to protect the interests of the public. And so historically, that is how many participants in our proceedings, including, the commission itself, has viewed, the overarching authority to inspect records.
If I can make a comment, that's kind of shocking to me. I mean, I don't know if you guys have had a court opinion regarding that, but I look at an attorney-client communication as an absolute privilege. And wow, I'm just kind of shocked by, I guess I look forward to continuing to hear this bill, but that's really interesting to me. I practice in the civil realm, which I know is a little different, but there's business laws like under our titles for business laws where business records are open to inspection by there's that, and that doesn't waive a privilege still. So that's interesting to me. So thank you for your explanation.
For the record, Garrett, we're just a quick response. The thing that's, fortunately, this bill is not proposing to change that. And so there's a mechanism through which a party who believes that the commission has ruled in a way that is contrary to the law with regard to, that authority or has ordered disclosure of something for which the party is claiming a privilege, there would be the opportunity to appeal for it to go to a court for ultimately judicial review. And again, this bill is not addressing that authority. It is merely related to information that is provided, maintaining that protection as privileged.
All right, we're going to move on to Assemblymember Yurick.
Thank you, Chair, and I really appreciate how you've explained this because like my colleague, I think I'm bringing some of my concept and understanding of privilege from my civil context. As I have listened to the presentation, I read obviously the bill, and I'm looking at the amendment. It seems to me that the intent of this bill is to basically encourage these applicable regulated entities to be fully transparent with and cooperate with the commission and the investigative staff without fear of losing their evidentiary privilege. It seems to me that's what is attempting to be accomplished. So I appreciate, again, that explanation. Can you help me understand, is this bill then an attempt to be prophylactic and proactive to address this issue to encourage that cooperation? Or do we have examples of where a judge has actually subsequently deemed cooperation with your commission and investigative staff to have waived their privilege to this information?
For the record, Garrett Weir, great question. So we haven't had any instances of a court ultimately weighing in on that issue, but you're absolutely right. This is an attempt to be proactive. We're seeing concerns that have been raised about the effect of sharing that information, and we want to proactively address that concern and encourage that sharing of information. And again, to just speak to the distinction here, because I think, yes, attorney-client privilege is a sacred thing. But the law that was passed, I think, was recognizing the unique type of entity a public utility is, and that unique type of regulation that occurs, and the need for that ability to examine things that are otherwise, that are important in determining, to making sure that people are receiving safe, reliable service affordably. And, an example, we're talking about the attorney-client privilege, but NRS 49 also identifies the accountant privilege. Well, should the regulator get to see an audit that's performed that reveals some, concerning information about the way that a utility is being managed? Those are the kinds of policy questions here about, how much should that privilege protect this unique kind of entity?
All right, thank you. We made sure to give ample time to our fellow attorneys on this committee to dig in on this. Members, any additional questions? All right. Seeing none, thank you very much for the presentation, Mr. Weir. With that, we will move on to testimony in support of Assembly Bill number 46. Anyone wishing to provide testimony in support, either here in Carson City or remotely, please come forward. Please go ahead.
Good afternoon, Chair Watts and members of the committee. My name is Tony Sanchez, and I'm the Executive Vice President of Business Development and External Relations for NV Energy. Appreciate the committee's patience and latitude and the opportunity to work with the Utility Commission on some initial concerns that we had, but we do concur with Mr. Weir's testimony prior to mine. Bottom line, the purpose and intent of the amendment, the conceptual amendment that we have proposed in working with the Utility Commission and Southwest Gas is to foster greater transparency in proceedings before the Commission. This amendment does not mandate that we have to disclose privileged information. We obviously share the concerns expressed by your colleagues with respect to our ability to maintain attorney-client privilege, but it just provides legal safeguards that if we do choose to share that information, what happens to the information. It doesn't dictate who gets access to the information. All those are already subject to Chapter 49 and other confidentiality provisions throughout Nevada law. So it just adds additional language to the Public Utility Commission Chapter 703 that aligns with established gaming law provisions, and so it mirrors that language to foster transparency and a greater opportunity. So these things don't have to get litigated in front of the Commission, and it provides for codifying what could be described as standard practice without having previously been contained in law. And we just think it provides a more clear and effective method to achieve that transparency. Now, with respect to the conceptual amendment, I do believe it probably needs a small amount of work and input from other parties that we've heard of since as of today. So we would ask that we, but obviously subject to the chair's discretion, could use a very small amount of time to address any other issues that might arise from today. But with that, happy to answer any questions or turn it over to my colleague from Southwest Gas.
Thank you. I think we'll turn it over to the representative from Southwest Gas, and then we'll see if members have any questions about the amendment itself. Every member should have a copy of the amendment on their desk, and I believe there are copies provided for the public as well. It was submitted late, but we did want to make sure that it was available so that we could discuss it today. So, Mr. Keith, please go ahead.
Good afternoon, Chair and members of the committee. My name is Dylan Keith. I'm the Senior Manager of Government Affairs for Southwest Gas. I wanted to quickly echo the comments from my colleague at NV Energy. We are in support of Assembly Bill 46 as amended. We would especially like to thank Mr. Weir as well as his staff for working with us, as well as you, Chair, and the members for your grace and ability for the time to get this right and really work on the language to make sure it works best for all parties. With that, thank you.
Thank you both. Members, any questions for either of the utilities on the amendment language? Okay, seeing none. Thank you.
Good afternoon, Chair, members of the committee. Lucas Folletta. I represent Boyd Gaming Corporation, Venetian Las Vegas, and Station Casinos, LLC. I'm also an attorney and I practice before the commission. We are in support of the bill as written. I think we're in support of the bill as written, which apparently the proposal is going to shift a bit and that language is going to come out and there's going to be some new language inserted. I feel compelled to address the language of the amendment as it's been presented today because I do think it's not entirely consistent with what the utility and the commission has suggested is their intent. I don't believe that's necessarily purposeful, but I think we should talk about it just for a minute. I also think we should address the notion that it's sort of counterintuitive or potentially concerning that the commission as a regulator has access to privileged information from public utilities. And I appreciate that it may be counterintuitive to lawyers that practice outside of this realm. The public utility is a regulated utility. It doesn't operate in a competitive space. Litigated settlements, jury awards, these are all things that ratepayers are asked to pay after the fact. The only way to evaluate the reasonableness of those requests by the utility that the cost of those things be passed on to ratepayers is to, in some cases, evaluate some of the privileged information that's generated in the course of those court cases or settlement discussions. It has frequently been the case over the years that that type of information has been presented to the utility, or excuse me, to the regulator without objection. And because they recognize that if they want somebody else to pay for those things, that they're going to have to justify it. I'll give you an example of a wildfire. We haven't had one here yet, but let's talk about a California situation where there's a lawsuit over who caused a wildfire. Reports are generated internally by the utility who's accused of causing it as to the causation of the fire. That information clearly should be given to the regulator when that utility comes to the regulator and says, we need the ratepayer to cover the $1 billion damage award that we were just subject to. So that goes to the reason of the books and records privilege, which I'll call the commission's privilege. On this amendment, if you look at it, what my concern is that it goes beyond the simple rule of saying disclosure of that information to your regulator is not a waiver. I agree with that. That should be the rule, and I think, frankly, it already is. That said, if you look at Section 6, it says, any communication or document of the public utility transmitted to the commission for a variety of reasons, including C, assisting the commission in the performance of their respective duties, is absolutely privileged. That creates, in my mind, a new privilege. That means anything the utility gives the commission in the course of a case is absolutely privileged. That's not the same thing as saying you're not waiving an existing privilege by submitting that information. So I am concerned that that is significantly overbroad. I'm also concerned with the idea that, as that sentence goes on, that conveying that information does not impose liability for defamation or constitute a ground for recovery in any civil action. That creates a giant liability shield. If I produce information in the course of a PUC case that indicates I was liable for a wildfire, and now this rule is that that document, whatever it is or was, some report created by the utility, cannot be grounds for liability in a civil context, that would be hugely problematic, I think, for anybody affected by the fire. It also creates the possibility that the commission's process is used as a liability shield. If you're the utility, you're just going to dump everything you have into the commission and its process and claim that this rule protects you from liability associated with that instance because you gave it to the commission. I don't think anybody wants that. Section 7 seems to reflect the original intent of the bill, which I think I agree with. Section 8, I'm also concerned about. It suggests that the commission cannot release privileged information without the consent of the utility. Well, under our process, the commission's in charge of the utility, not vice versa. This also suggests that the commission or staff cannot give this information to the Bureau of Consumer Protection. The Bureau of Consumer Protection is a regulator. They're entitled. They have the same books and records privileges as the commission staff. The commission, you'll see the Bureau of Consumer Protection is referenced in the original version of the bill and it's not referenced here. I'm a little concerned that there's a possibility this could be construed to prevent the commission or staff from giving privileged information to the Bureau of Consumer Protection, which would create an aberration. That's not a situation that exists today. I'm also concerned about the commission being put in the position of having to litigate its own ability to disclose something to a third party based on its view that something is not privileged, right? So this says you can't give away a privileged document. Okay, but who's going to decide that? Now the commission may be concerned about disclosing this information because even if they feel it's not privileged, and that could chill the ability of parties in these cases to access privileged non-privileged information because the commission's worried about the utility when it raises its hand and says, we think that's privileged. So I think, that can get worked out in the context of these cases, and it does. But if we provide a new rule that says the commission can't give it out, and that new rule is the basis for a legal action from the utility that says to a court, they can't give this out, we now got a new situation. So if we're trying to codify sort of an existing rule about the waiver of privileges associated with utility information given to the Public Utilities Commission, I think that's appropriate, and I think the utility should have that protection. But we shouldn't go any further than that, and this definitely, as written, does. So thank you.
Thank you for providing that information. I'm not exactly sure how to classify testimony in support of the original bill, but raising concerns about the amendment that was brought by a third party that's mostly accepted by the sponsor. So I think we might just go with neutral on that. But we do appreciate the additional information. Would anyone else like to testify in support of Assembly Bill 46? Seeing nobody coming forward, AVH, is anyone on the line to testify in support of AB 46 by phone?
To testify in support of Assembly Bill 46, please press star 9 to take your place in the queue. Hello?
Yes, we can hear you. Please spell your name for the record, and then you can begin.
Good afternoon. My name is Ernest Figueroa. That's ERNEST FIGUEROA. I am the Nevada Consumer Advocate and Chief Deputy Attorney General, the Executive Head of the Bureau of Consumer Protection. I am here testifying in support of AB 46 as introduced. I echo the concerns of Mr. Folletta. So I don't know if you want to alter my position as a neutral chair, but you do so as you wish. But at the end of the day, I just want to say that I look forward to working with the bill sponsor and the conceptual amendment stakeholders to see if we could get to some sort of consensus so we get this bill pushed through. Thank you.
Thank you for your comments, Mr. Figueroa. I think we will just go with neutral on that, but appreciate you providing your position and that information for the record. AVH, next caller, please.
Here, there are no more callers choosing to testify in support at this time.
All right. With that, we'll move on to testimony in opposition of Assembly Bill 46. If anyone would like to provide testimony in opposition, please come forward. Seeing nobody, AVH, has anybody joined us by phone?
Testify in opposition to Assembly Bill 46, please press star 9 to take your place in the queue.
Hello. Can you hear me?
Yes, we can. Please spell your name.
Hello?
Please state and
Oh.
spell your name for the record, and you can begin.
Okay, my name is Kim Fergus, KIMFERGUS. I would like to say hello, and I don't want to sound kind of goofy on this, but I'm a little confused. So I am in total opposition of AB 46, seeing that the way I see it, it's protecting utility companies, not consumers. And I do have a personal thing that happened like a year ago with the PUCN. AB 46 is a dangerous expansion of government overreach that prioritizes utility companies over consumers, particularly in Clark County, where the Public Utilities Commission of Nevada, PUCN, already wields too much unchecked power. The bill further shields utility companies like Southwest Gas from public accountability when offering zero protection for struggling ratepayers. Consumers are already facing astronomical rate hikes, with some gas bills increasing by $100 per month, yet the PUCN continues to approve these increases without explanation or jurisdiction. Instead of ensuring transparency, AB 46 allows utility companies to hide behind confidentiality laws, making it even harder for the public to know why prices are skyrocketing. By expanding secrecy provisions, this bill will make it nearly impossible for consumers and watchdog groups to challenge unjustified price hikes. The PUCN, which should be protecting the public, is instead acting as a shield for monopolistic utilities, blocking public oversight and allowing corporations to maximize profits at the expense of the Nevada residents. Rather than passing laws that protect corporate interests, lawmakers should be fighting for transparency, public participation, and stronger consumer protections. AB 46 must be rejected in the favor of legislation that limits PUCN's power, mandates public hearings for rate increases, and holds utilities accountable for every dollar they change. And I'm sorry if I sound abrupt or whatever, but that is my feeling on this bill. Thank you.
Thank you very much for providing your comments. We appreciate you calling in. AVH, next caller, please.
Chair, there are no more callers to provide opposition testimony at this time.
All right, thank you. With that, we'll move on to testimony in neutral on Assembly Bill 46.
Good afternoon, Chair, members of the committee. For the record, my name is Jimmy Lau with Ferrari Reader Public Affairs representing Western Resource Advocates. Western Resource Advocates was supportive of the bill as it was introduced, and we are reviewing the amendment, but do have some concerns with the change in language. Thank you.
Thank you very much. Seeing nobody else coming forward in person at this time, AVH, is there anyone wishing to provide testimony in neutral on AB 46 by phone?
Chair, there are no callers to testify in neutral at this time.
All right, thank you. Mr. Weir, would you like to make any closing comments?
For the record, Garrett Weir. I'll just conclude by saying that we will continue to work with the stakeholders to achieve consensus. It seems like most people, mostly everyone, appreciates the intent of the bill as introduced, and I'm hopeful that we'll be able to craft some language that alleviates everyone's concerns. So hopefully language will be forthcoming.
Thank you. Please keep me apprised of those efforts as they move forward. All right, that will conclude our hearing. So I'll close the hearing on Assembly Bill 46, and we will move on to the last item on our agenda today, which is public comment. If you would like to provide public comment, please call in at 888-475-4499. When prompted, please provide the meeting ID 899-3076-0675 and then press pound. With that, if anyone would like to provide public comment, either here in Carson City or in Las Vegas, seeing nobody coming forward, AVH, has anyone joined us to provide public comment by phone?
Chair, there are no callers to provide public comment at this time.
All right, thank you very much, members. That concludes our business for today. Our next meeting will be on Tuesday, March 11th at 1:30 p.m. This meeting's adjourned.
Thanks, Chair.